Judiciary Committee on the 25th of January, and today we're going to be starting to take up Bill H-89. Before we do so, just I guess we'll call this an announcement. So I'm going to be postponing consideration of H-41. Had that down for a vote on Friday. Given some various things that came up yesterday, testimony, subsequent email from the state's attorney, Representative Tim Leaders Dumont, decided to postpone that. We'll probably be taking it up next Wednesday or Thursday. Going to give the stakeholders a little time to try to work together to figure the best way forward. So just wanted to let folks know that. I do continue to hope to, or planning on having a vote on the H-45, the abuse of litigation. It was my sense that we all seem to be on board with that one, but there are still issues with respect to H-41. So H-89, I'm just going to give a little context before we start with a walkthrough by Michelle Childs of the Legislative Council. So the Supreme Court's opinion overruling Roe v. Wade has left the protection of reproductive rights to individual states. Vermonters understood this threat that the U.S. Supreme Court posed to reproductive liberty and wisely started work on protecting these rights over 4 years ago. That work culminated this past November in the voters overwhelmingly approving a constitutional amendment protecting rights, reproductive rights and bodily autonomy. So many states have also attempted to limit access to LGBTQ plus youth to gender affirming care, healthcare, such as hormone therapy. For example, last year, the Alabama governor signed a bill into law that prohibits transgender minors from receiving gender-affirming care, with any person who engages in or causes a transgender minor to receive such care facing a felony punishable by up to 10 years in prison or a fine up to $15,000. In contrast, in a resolution last year, the Vermont legislature condemned actions of states to ban best practice medical care for transgender youth and prosecuting parents for seeking such essential care for their children. It further committed to exploring all available options to ensure that transgender youth and their families are safe in Vermont to make the best medical care decisions for themselves in consultation with their healthcare providers. So with the introduction of H-89, the House is now poised to take the next step in protecting patients' access to reproductive care as well as gender-affirming care. H-89 would create a so-called shield law to protect Vermont doctors, nurses, and others for providing reproductive or gender-affirming health care that is legal here in Vermont. The law would also provide protections to patients receiving such legally protected health care from these Vermont clinicians. So states that have passed or are passing laws restricting reproductive or gender-affirming health care are creating civil sanctions against those involved in providing such care, and even criminalizing such care. And they are also likely to use these sanctions to stop abortions that happen beyond their borders. They will try to do this. When the residents come to Vermont and receive reproductive or gender-affirming care, these states will try to hold Vermont providers criminally or civilly liable. H-89 would check the overreach of other states. It would advance protections against abusive litigation, which we're going to be getting the definition of shortly. So that's just kind of sets up why we're taking up H-89 for the next couple of days and probably into next week as well. And I turn it over to Michelle now. Thank you.
Good morning. So for the record, Michelle Childs, Office of Legislative Counsel, and we are taking up H-89 as introduced, but, and the chair did a great job about giving kind of an overview of why the sponsors are putting forth the legislation. But I wanted to give you also just a little background too, before we dive into the language. So I am going to going to share my screen. Can everybody see that okay? Okay, great. So we're gonna. Nina, how do I get, I need to be able to toggle back and forth between the different things on my Chrome without this little thing up top. Do you know what I'm saying? Like I need to be able to go back and forth between that. Sorry, I already warned her I'm not the best Zoomer.
Oh,
Do you know what I mean? Or do I?
go to more real quick.
I mean, I could.
Video panel, I think. Right there. Or meeting controls, one of these. And the meeting controls, I think, will have that for you. These right here.
Oh, perfect. Great. Thank you. So I just wanted to start out just kind of showing you what we do have currently in law and kind of the background. The chair mentioned around reproductive rights being protected in Vermont, and everybody I'm sure is familiar with the constitutional amendment that was passed in November. But we also, prior to that, because the process for constitutional amendment is a 4-year process, and that the amendment has to pass one biennium, and then it has to carry over to a second biennium and pass that before it goes to the voters. And while that was moving along in its process, the General Assembly adopted a statutory scheme also protecting reproductive rights. And so I just wanted to show you what's there in law. And we don't need to go, I'm not going to go in and talk about abortion rights and things like that. I'm just letting you know where we have these areas in law. There's also, as the chair mentioned, the joint resolution that was adopted by the General Assembly last year. And this was specifically addressing the issue that the chair mentioned around in response to other states adopting laws that were prohibiting youth from obtaining gender affirming care in those states. And so I wanted to direct your attention to the bottom. So there's findings there. And then at the bottom, you'll see it's resolved by the Senate and House of Representatives that the General Assembly condemns the actions of states to ban best practice medical care for transgender youth and prosecute parents for seeking such essential care for their children. And be it further resolved that the General Assembly shall explore all available options to ensure that transgender youth and their families are safe in Vermont to make the best medical care decisions for themselves in consultation with their healthcare providers. So I just wanted to kind of note where you already have acknowledged as a body the right to obtain reproductive healthcare services and gender affirming healthcare services, because when we get into the draft, you'll see that both of those are included within a definition of legally protected healthcare. And so we're talking about both of those issues. And then as the chair mentioned, there's a lot been going on since the Dobbs decision. All right, I guess I'll just do that. And I just wanted to take, sorry. Really?
Michelle,
I know.
That's good right there for a second.
Oh, okay. Wait, no, I don't want to share. I definitely don't want to share my email. I'll let Barbara in. I'm sorry, Mark, Tom, go ahead.
If you could bring.
I'll go back to it. Yep.
The second paragraph up says, resolve that General Assembly shall explore all available options to ensure that transgender youth and their families are safe in Vermont, which I don't think anybody has any real issue with. I'm just wondering about the wording in the order that it's worded, ensure that the transgender youth is before and their families, if youth could be take advantage, I guess, of the practices without their families knowing.
That is not an issue, that's not addressed in here. I don't know necessarily in terms of parental consent to healthcare issues, things like that. I think the healthcare committees deal with that. I don't think this doesn't change anything with regard to parents' involvement in their healthcare decisions of their children.
Does it change anything so that parents may not have a say?
No,
No, it doesn't change anything. What do you mean by no, they don't have a say or?
no, it doesn't change anything. So the resolution is strictly saying that they're supportive of transgender youth being able to obtain services in Vermont.
Okay. So
And
it doesn't.
It doesn't change the law. There's
I realize that.
right. It
Yeah.
doesn't say parents don't have a say, doesn't do any of that.
So, okay, so it doesn't support, it doesn't support any of that, okay.
Nope. It's
Okay.
just saying that, it's a decision. So with both of the issues, reproductive rights and gender affirming care, I think the nut of it is that, the patient provider relationship is that the state is not going to be involved in that in terms of regulating that. And so that it's just being supportive of people being able to access care here in Vermont. But that helpful?
Oh, yeah, definitely. I might have a couple more questions once we get into.
Sure. And I'm gonna have to stop sharing for just a minute so that I can get back to that webpage that I just, sorry. I think IT might need to spend a little time with me this summer. So what I'm gonna show you essentially is what the country looks like a little bit with regard to like post-Dobbs, which is that, so we used to have an interpretation with Roe that there was a constitutional right to abortion. And then with the Dobbs decision, it's being left to the states. And what you wind up with is a real patchwork around the country. And I think looking at a map is helpful. Sorry about this.
Don't have to apologize. I think it's really stressful. It can be really stressful trying to manage computer stuff with Zoom and everything. It's totally understandable.
I've been asking for like an aide to just follow me around all day. But hasn't happened yet.
It's uniquely stressful. You feel like you're going to hit the wrong button and something terrible is going to happen.
Of course, you didn't think of that. You've just added.
Yes, thank you.
I'm here to say nothing terrible is going to happen.
Nothing terrible.
Nothing terrible.
Thank you.
And no one is thinking, hurry up, hurry up.
I appreciate. I know I've got a friendly audience, which always makes it much easier.
There's not a single teenager at this table.
My teenagers do shame me on a weekly basis about my skills, for sure.
No, if they're the teenager, they would just be taking over.
Right. Yeah.
Yes, I think that's probably one of the reasons why I don't know what I'm doing. Between our amazing IT staff here and my teens, I really haven't had to learn this stuff. There we go. Okay, so just what I wanted to show you here, and there's a variety of different organizations that have these maps. So like the Guttmacher Institute, and the Center for Reproductive Rights, I think they have their own maps where you can go on and do this. But so what you want to see here, so, and this is just so you know, this organization, it's the Center for Public Health Law Research out of Temple University School of Law. This map was only updated, I think, up to last August. They say that they're going to update it again in February. So there are other websites out there that have kind of really to the day updates what's going on, because it is changing on a weekly basis because of so much litigation going on around these issues. But I wanted to make sure that we're using a nonpartisan objective map here. So it is a little dated, so it may not be completely reflect everything that's going on. But you'll see all the states there. And then you can see on here, you can click on, and you can see the states that have restricted the legal status of abortion in some way, right? So you kind of see the areas there. And it could be any type of restriction there. Right.
Those are the states you just clicked on that protect reproductive rights, right?
Nope.
The yellow.
The yellow.
The yellow is what I'm looking at.
The yellow are the ones that restrict abortion in some
I was
way.
looking at the non-yellow ones.
Oh, sorry. So I don't know how to make.
No, that's fine. I just didn't know which was which.
If I mess around with it, I'll goof it up. So then below there, you can look and it'll give you examples of how is abortion restricted in those states. So, and they have different categories. There can be a total ban. There could be bans with limited exceptions. There can be a 6-week gestational limit. There can be other gestational limits. There's something, you may have heard about the fetal heartbeat, where there's if there's a detection of some type of cardiac activity, those laws there. There's reason-based bans, and then there's method bans. So things like third trimester, things like that. So what you can see is there's a lot there, and all these states have a kind of a hodgepodge of different laws, and some of them were in effect pre-Dobbs. Some states, you might have heard the term trigger laws, where in anticipation of the Dobbs decision, there were a lot of state legislatures that passed legislation that kind of had a trigger, so that if Roe was overturned, then those laws would then take effect. So you can see, like here, it talks about trigger laws. There you can look at these and you can see whether or not does the state explicitly restrict medicated abortion. I believe, I don't know the stats now, but the majority of abortions that occur in the United States now are medicated abortions. It is now a 2-pill regimen where the pills are taken about 48 hours, I believe, apart. That is important when we're talking about these issues, because one of the tricky issues is, where does the abortion occur? So with telemedicine now becoming so prevalent, and with medicated abortion being that, the patient can take the medication wherever they are, then there's a question of, where does the abortion occur? So I just kind of wanted to highlight that.
Can you say that again?
Sure.
What do you mean, where does abortion occur?
So an example is that if you have a provider in one state who prescribes medication for a patient in another state. So it's presenting some novel legal issues around, where is the conduct occurring? Is it where the patient is and they're taking the medication? So
Could be an advantage or disadvantage either way for somebody legally. I mean,
yeah, it just starts to get very complicated when we're talking about jurisdictional issues and states that are restricting access. And we'll once I start to kind of walk through the language and talk about some of the stuff. And then also you have some great witnesses over the next couple of days.
There's some clarification in here.
About where the abortion occurs.
Right.
It talks about choice of law. I think if you could just kind of hold that, and as we start to walk through, hopefully we'll start. Yeah. So then there's also that, just I mentioned the telehealth. So these are the states that explicitly restrict telehealth for abortion care. So, I think just my point in showing you this is so that you can see that there's no national standard, right? So there's no floor anymore, like what we had with the constitutional protections. Also, before I get off of this one, they're all something that I'm going to be talking about, and I believe that the chair mentioned. Did you mention SB 8 in Texas as an example? There is a law in Texas, and this is a new approach where using civil lawsuits where any person can bring a suit against someone for either providing or facilitating an abortion. And this is kind of a new approach looking at using a civil process with regular citizens to enforce an abortion ban rather than it being the state officers who are specifically prohibited from enforcing that abortion ban. And so that's when we see here is around, and I think that's a little broad. I think that's including other things around other types of civil litigation. So it's probably a little broader than we need. Okay, I don't need to do that anymore. So I'm just going to start to walk you through the bill. That's all right. So one thing I wanted to just start out with generally is talking a little bit about the idea of full faith and credit. And I think that we might have talked about that. I don't remember why in this committee recently, but maybe not. Maybe I just talked about it so much otherwise. But so the federal constitution provides that states generally have to give what they call full faith and credit to the legislative acts and judicial the judgments of other states. And so the idea behind this is that in a federal system that we have, right? So is that you have all different state laws and you have courts issuing judgments in the different states. And if there is not comity and recognition of those other statutes and judgments in the various states, then there's can be chaos, right? So an example would be, I have an order with regard to legal rights and responsibilities for my kids with my ex-spouse, and if I could, and that was issued by a Vermont court, if I could move over to, if I didn't like that order, and I could just move to across the river to New Hampshire, and New Hampshire says, well, that's a Vermont order, we're not going to recognize that. Then, people can basically be, choosing venue and basically evading those orders. And so the general principle is that states are going to be, are required, and there's a higher standard with judgments than there are with state statutes. But that's generally how things work. And so that's an issue that's going to come up in these and that we'll be talking about over the next couple of weeks. And I think, just a little reminder, I'm a generalist. I'm your legislative lawyer, so I know how to do legislative things, but I'm not, I don't have a deep expertise in these particular issues, but we can make sure that you get the resources and the witnesses and everything that you need around those particular issues. Mm-hmm.
Is full faith and credit or in credit? What is it?
Full faith and credit.
And credit.
Mm-hmm.
And is that in the Constitution?
It is. And I can provide, if people want citations or, things like that. I have a ton of materials I can actually, or I'll read into the record, the full faith and credit clause. So Article 4, Section 1, full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. And Congress may, by general laws, prescribe the manner in which such acts, records, and proceedings shall be proved and the effect thereof. And Congress did adopt legislation, I think it was in the 40s, that details how you verify those and the effects of that. So we're going to start at the beginnings, which actually starts, I think the bill language doesn't actually start till page 4. And so we're starting with section 1, and you'll see, I always like to kind of draw your attention to the title that we're working in. So this is an amendment to Title 1, and this particular chapter where this is adding a new statutory section is where we have construction of statutes. So you know how I'm always saying, if people say, if I say the word including in a bill and somebody says, but not limited to. And I say, we actually don't need that because there's something in Vermont statute that says when you read that term throughout all 33 titles, this is what that term means. And so what we're doing here in section 1, I'm sorry.
I know you're starting on page 4 with section 1, but I'm just wondering if it wouldn't be useful to go through the subject since it is so long.
Sure, happy to. Mm-hmm. Okay, so we're going to start on page 3 on statement of purpose. So the first one being what I was just about to talk about in section 1 is to define legally protected healthcare activity. To include reproductive healthcare services and gender affirming healthcare. So just a little background, and I think probably the witnesses today can talk to you more about the Massachusetts experiences, that this bill is modeled after Massachusetts legislation that was adopted last summer. So when Dobbs came out, most state legislatures had already adjourned for the year. Because it was early summer, we had already adjourned. But the states that were still in session, that were inclined to, started enacting different provisions with regard to shield laws. So, they were kind of a little bit piecemealed. And then there were other states that did it through executive order. We have a more limited authority with regard to executive order, but there were some states. So the states that were inclined to say, we protect reproductive rights and gender affirming care here in these states, and we're concerned about extraterritorial application by states that were restricting those laws. They started kind of passing these, and Massachusetts did so, I believe, in July, and they were the ones that did the most kind of comprehensive in one package shield law bill. And so, in working at the direction of the sponsors of this bill, I connected with folks in Massachusetts and was using the legislation that passed in Massachusetts as a model. And so that's where you'll see a lot of this language came from, and specifically the definition for legally protected healthcare. The second issue you'll see starts on line 6, which is it exempts cases involving tortious interference with legally protected healthcare activity from the SLAPP statute. That's kind of a mouthful. So SLAPP means strategic lawsuits against public participation. And that was a law y'all adopted, I don't know, but it's been a while. It's been over a decade. And that is restricting litigation where the purpose is basically to, and you're familiar with the kind of idea of abusive litigation, someone is using kind of strategic lawsuits to discourage someone from engaging in public participation. So an example, not to pick on developers, but, the idea would be like if you had, a big developer wants to put in some huge project and some folks in the local community are concerned and are opposed to it, and they are going before their DRB and they're going before their city council and raising concerns. If that developer was constantly filing litigation against them, and the goal of that was to discourage, to kind of be like, make them fearful of participating in that process, then that would be a violation of the SLAPP statute. And the only reason why that's even in here is just to clarify that, because later on there is a new cause of action that's created, which is the ability for someone to sue someone who has already sued them around and the issue is interfering with their ability to obtain legally protected health care. And it'll make sense once I get to it.
So the SLAPP, I think that should be changed, but that's the SLAPP statute, is that to protect? It's to protect, I realize that, but is it within the state, or is that still pertaining to another state?
Well, this is all, so the SLAPP statute that we have here, I mean, all of this stuff, we can only control what's in Vermont.
Right.
We're not looking to go outside. I mean, I think what the idea behind the shield laws is that there are states that are adopting laws where they're trying to reach beyond their borders and affect conduct that occurs outside their jurisdiction. So we're just, pardon?
I said, I don't like that.
So the SLAPP suit is just the existing statute has to do with making sure that people feel like they can lobby their legislature, that they can go before their city council and they can speak their mind and they can advocate, and that somebody maybe with some deep pockets isn't going to constantly be filing things against them to discourage them from doing that. And so once we go through, and it's a little backwards because we're talking about SLAPPs before we talk about the tort, but just it'll start to unfold and make sense.
Similarities to H41.
On abusive litigation, yes, and there is an abusive litigation chapter in here.
Well, yeah, but still, there's a lot of similarities.
Okay.
So slap one more time, strategic lawsuits against public participation. Oh my God, I remember.
Good job. Okay, moving on to the third one. Prohibiting civil arrest of a person for purposes of abusive litigation with regard to legally protected healthcare activity. There is a provision that you have in law around allowing civil arrest, which is arrest for purposes of obtaining a person's presence or attendance at a civil proceeding. So there's a process there. And what this bill does is say that you can't use that process to civilly arrest a person for the purpose of showing up at a hearing with regard to abusive litigation concerning legally protected health care. Next one on line 9 is it establishes a cause of action regarding tortious interference with legally protected healthcare activity. That is the concept of when we talk about like a law like SB 8 that allows citizens to initiate a civil lawsuit against any person who has provided or facilitates an abortion. If someone then sued someone, this provides an avenue to file a claim against that person for interfering with their ability to either provide or obtain legally protected health care. On line 10, next is prohibiting a court from ordering a person to give testimony or a statement or produce documents or other things for use in connection with litigation involving legally protected healthcare activity. And again, Tom, to your point, when you think about this, a lot of this is saying, so we can't control what's going on in other states, right? But you can, and it's the goal of this legislation in many ways, say, well, we're not going to cooperate that. It's against our public policy to be prosecuting people from seeking healthcare services. And so we're not gonna say you can do what you are doing in that state, but if you're trying to involve us in it, we're not gonna help you.
Can't disagree with that.
And so along those lines, if you look at line 13, it prohibits a public agency from cooperating in an interstate investigation or proceeding seeking to impose either civil or criminal liability upon a person for obtaining or providing legally protected health care. Line 16, the next one, it establishes a misdemeanor crime for using force or threat or force of physical obstruction to interfere with someone obtaining protected health care. That is modeling, there's a number of states that have this, but there's also a federal act called the Freedom of Access to Clinics Act. That basically says you cannot, if someone is trying to, and this bill applies to whether or not the person is seeking reproductive services or gender affirming care, but the federal act has to do strictly with reproductive services, and basically says you cannot, obstruct someone from being able to enter the building, enter the facility. You can't be threatening them. You have to allow people basically access to get into the healthcare facility. Next one on line 18, it prohibits the extradition of a non-fugitive person in connection with abusive litigation in another jurisdiction. So the federal constitution requires states to extradite people who are fugitives from justice in another state. So if someone is, again, thinking about what I was just talking about, like the full faith and credit piece, the same idea, which is that, if I can go over to New Hampshire and commit all kinds of crimes and get in trouble, and they convict me over there. If I can hop over the river, and then I'm free, then it doesn't make a lot of sense, right? And so there's the recognition that we're to recognize those judgments in those other states. And so we are required to extradite folks. However, there is a little room there so that around the issue of, has the person fled the jurisdiction, right? And so you'll see when we get into the language here around this particular issue is that we would not have to do so if the person that the demanding state is asking to be sent was actually in Vermont at the time of the alleged conduct. So if they didn't flee that jurisdiction, if they were just here and that's where the conduct occurred, but they were trying to reach into Vermont and say, okay, you provided this care or you facilitated this particular access to care, but you did it in Vermont. This is saying, well, we're not going to extradite that person to that other state.
To jump back, apologize for jumping back.
That's okay.
Line 16, establish a misdemeanor crime for using force or threat of force in the physical obstruction. Don't we already have some laws around that a number of years ago with, I think some of the Planned Parenthoods in Vermont, people were obstructing people from going in?
That may be so. I don't, I think there are probably laws on the books, whether you looked at maybe disorderly conduct or things like that, that aren't specifically targeting those types of activities. I think the concern amongst sponsors was whether or not those laws were comprehensive enough to include the type of activity that you might see if in those particular circumstances. I think the federal act was adopted mid-90s when there was a lot of that activity kind of nationwide. And I think that was at the time where you saw some providers who had been killed and, there was a lot of things like that. And so this is a model at that, and it's geared more specifically towards the ability of people to access that particular facility without interference and being threatened.
Yeah, it seems like there was some distance.
You might be recalling, in Burlington had a city ordinance, and it may still be on the books, but not applied, something similar to this, but they had created what's called a bubble zone, which is like there's like a safety zone. There was a court decision, I believe in 2014, having to do with a Massachusetts law that struck that one down with regard to Massachusetts law. And now there are, I think, a few states that still have some kind of bubble zone or area of protection. And I think they have perhaps, I think they've withstood challenge, but I think probably Mr. Cohn can talk about those particular issues. I don't have a lot of information on that, but the sponsors decided they did not want to take that approach with regard to bubble zones because of kind of just that it's hard to enforce, kind of distant in how you do that. And so they thought taking the more kind of standard approach and modeling more what's in the federal law was better.
No, it makes sense. I just remembered something that happened at some point somewhere.
Sure.
In Vermont.
Yeah, well, you got a great memory there. That's the next one is line 19, prohibiting a court from issuing a summons when a prosecution is pending in another state concerning legally protected health care, or where a grand jury investigation concerning legally protected healthcare activity has commenced. And so this is just kind of like witness protection. So like if it's saying that a Vermont court is not to order someone to show up to a hearing or to give testimony or anything like that if it's concerning abusive litigation with regard to legally protected healthcare. And then the last one, I think we're down to the very last one, is on line 4, and that's expanding eligibility to the address confidentiality program for any person who's either providing, assisting another person in obtaining for themselves reproductive health care or gender affirming care services. And so there is a program called Safe at Home that is housed in the Secretary of State's office. And this was created so that survivors of domestic and sexual violence can apply to the Secretary of State's office and then have essentially a legal address that they use that is not necessarily like their home address. It provides them a level of safety if they are in fear for either themselves or their children. And this would expand that to allow folks who are either providing the legally protected health care or obtaining that health care for themselves, or, it could be volunteers at a clinic. And so this is not, it doesn't automatically apply. It's something that you would have to make application to the Secretary of State's office to get on the Safe at Home program. And I believe you have Lauren Hibbert coming in maybe tomorrow to talk to you about the Safe at Home program. All right. Thanks, Tom. I think that was a good idea.
Thank you.
So, all right, now we're going to go to page 4. So legally protected healthcare activity. So you see there's 3 definitions here. And again, they apply throughout the title. So you'll oftentimes see when I'm working in different titles, there may be a definition section, and then it'll say gender affirming care means as provided in 1 VSA 150. And that's just kind of like a directive. I wouldn't necessarily need to put it in there because this, having the Title I definition would apply throughout, but it helps people if they're just reading something, they'll be like, they read the statute and say, well, I don't know what legally protected healthcare is. So it's just like a pointer system. But you see the definition of gender affirming healthcare services. These definitions that are in this section are identical to the ones that were adopted in Massachusetts with just a couple small tweaks. So you see on gender affirming healthcare services, the last sentence there, the sponsors chose to add here, which is just clarifying in case anybody was mistaken, that gender affirming healthcare does not include conversion therapy, as defined currently in Vermont law. Vermont law does ban conversion therapy for youth. And so it's just a reference there, just clarifying that that's not included.
Does it ban it for youth if, I'm sorry, I should
Go ahead, Tom.
jump in. Does it ban it for youth if the parents still would want to go in that direction?
I would need to look at the statute. I didn't do that one, but I'm happy to take a
I'm
look.
just curious.
Happy to take a look. And the witness, and I think Polly from GLAD, who's testifying this afternoon, she might know and be familiar with it. So you see the definition of legally protected healthcare activity. And so we're going to move up to page 5 at the top. Means, and I'm just going to read it because this one's really key because you're going to see it throughout the bill. It's the exercise and enjoyment or attempted exercise and enjoyment by any person of rights to reproductive healthcare services or gender affirming healthcare services secured by the state or the provision of insurance coverage for such services. So that definition, and I'll just let you know, I just got permission to, so there is a companion bill, I would say, to this. If you look at the states that are adopting shield laws, they are including some of the things that are in this bill, but also other provider protectors around licensing, around medical malpractice insurance, things like that. But those issues are not in this particular bill. They are in a bill that will be introduced either today or tomorrow in the Senate. And will be taken up by the Senate Health and Welfare Committee. And so I don't think I'm at liberty necessarily to share that draft yet until it is introduced, but it contains some of these things. So you might see things like when it talks about insurance or things like that. This bill is not dealing with those particular issues, but what we did is use the same exact definition so that if those two bills are moving at the same time and they pass during the same session, they're going to dovetail, and there's not going to be any conflict there when we get to May. So hopefully. So subdivision B, starting on line 5, or it includes any act or omission undertaken to aid or encourage or attempt to aid or encourage any person in the exercise of their rights. Again, looking to some of the other states, like if you look at Texas with SB 8, it's not just someone who provides an abortion who could be sued, but it's someone who facilitates or aids someone in obtaining that healthcare service. And so, there's a lot of questions about the extent to who does that apply to. There's a case now, and I haven't checked lately to see where it's at, but there's nonprofit organizations that provide funds to people who are seeking abortion care and might need money for travel or healthcare expenses, things like that. And they have challenged the Texas law saying, does this mean if we provide someone with some financial means or transportation or things like that in order to leave the state to obtain those healthcare services that are banned in Texas, does that mean that we would be running afoul of this law? And so, again, we're just not talking about providers, but we're talking about people who are aiding people in obtaining their health care. And then you look, and I want to just skip down to line 9. It's provided that the provision of the healthcare service by a person duly licensed under the laws of Vermont and physically present in the state, and the provision of insurance coverage for such services shall be legally protected if the service is permitted under the laws of this state, regardless of the patient's location. And so that is kind of the novel issue, which is like that I raised before, which is that we're kind of dealing with with the increase in telemedicine and with medicated abortion. It's not always that the provider and the patient are in the exact same location now.
Ken?
So a person could come from another state, and now I'm hearing pills can do an abortion, correct?
Yes, medicated abortion, yep.
So they can come to this state and it would have to be somebody in this state that gives them the prescription or whatever it is for the pills. And then they're all set, they've done what they wanted to do. And then they could go back to the state where they came from that wasn't legal and no charges can be charged against them, right?
Well, we can't control what that other state's gonna do.
Right?
What we can do is say, say we're not going to cooperate with if they're going to prosecute someone or they're going to allow civil enforcement of that ban and go after somebody for leaving the state to obtain that health care somewhere else. So we can't obviously tell Texas what to do.
Okay, so didn't I hear earlier that a lot of this stuff is paid for out of Medicaid?
I don't know. You mean like, is abortion covered by Medicaid? Is that what you're asking
Okay,
me?
yeah, we could, yeah.
I believe it is, but I'm not your expert on insurance coverage.
Okay. And then, so then the insurance coverage that I'm looking here, and let's just say on line 11, there are insurance companies that will pay for those, for that same medication for this part of healthcare.
Do insurance companies pay for that medication?
Yeah.
I presume so.
Thank you. Okay. And is there, have you got to be 18 or something to, or parental, no, you don't, do you?
We do not have a parental notification law.
Okay, yep, I knew that. Thank you.
I just want to direct your attention to line 14, subdivision 2, just clarifying that legally protected healthcare activity doesn't include service rendered below an applicable professional standard of care that would violate anti-discrimination laws. And so when you apply these protections, if someone is negligent, if someone is operating outside the scope of their practice, they are violating the standards of care that have been set up by the Board of Professional Regulation for whether it's nurses or physicians, that's not legally protected health care. So it's not barring, if somebody is injured through a procedure or things like that. This does not then give them immunity from those types of suits.
So I'm just curious if that then puts patients in a risky situation where if they go and ask for healthcare services and they get substandard service, are they now not protected with all of these protections that are vested?
No, that's what this is geared towards, ensuring that they continue to have those avenues available to them.
What if the provider is, not licensed and is lying about being licensed? And then
this is not going to protect them.
Right.
Right.
So this does put patients at risk if their provider is doing something outside of professional standards. Because their access to abortion services or to gender affirming care is no longer protected with all the rest of the stuff that we're going to talk about within this bill.
I'm sorry, I'm not following.
You're asking, I'm trying to make sure I understand.
So I think what just happened is that you said them and you were talking about the provider, and I think you answered from the perspective of the patient, maybe?
Oh.
So I think I understand, Ella, are you concerned that this from 14 to 16 would mean that a patient who receives
Substandard care
is not protected because this protects the provider?
No.
Like say that patient is from Texas.
Right.
And
No, if that provider is going outside the scope of their practice, if they are providing substandard care, this will not protect that provider. The patient still has their traditional remedies available to them to go after the provider for violating the standard of
I'm worried
care.
about Texas suing the patient for coming to Vermont and getting, unbeknownst to the patient, substandard care. And now all of a sudden they're not protected from going out to Vermont and we do extradite them or whatever because their provider happened to be lying to them about something or doing something outside professional conduct.
Right. That may be a math problem. I might need some time to do scribble around. And also probably, I think when you hear from the next witness, I think he's probably got just about every scenario. He's considered about every scenario of patient, provider, which state, where are you, what venue, and can probably answer that question better than I can.
Definitely make sure you ask that question when we have the other witnesses. Yeah, thanks.
I think you're just like way ahead of me thinking about this stuff.
Situation, but I
Right.
just.
No, this is great. This
The
is.
patient's responsibility.
This is what this process is for, is to really kind of explore all the implications of this language. Okay, we're off the definition section. All right, I'm going to move to page 6. So section 2 is the amendment to the SLAPP statute. So as I mentioned, SLAPP suits or lawsuits intended to censor or intimidate someone, to silence critics by burdening them with the cost of litigation. And so in hopes that they are not going to be publicly participating in lobbying their elected representatives. And this is simply an exception and it's just clarifying. I honestly, I don't know whether or not it's truly necessary. I think it's, it was included because Massachusetts included it in there as a safeguard. But the idea around this is that, and we'll get to the tort piece in a minute, is that if someone from Texas or sues under the Texas civil law, and they are suing someone for facilitating an abortion, and it falls under the definition that's in here for abusive litigation concerning legally protected health care. And there is a new right of action where someone can basically countersue. And this is saying that if you countersue, that's not considered a SLAPP. That's not a SLAPP lawsuit. Okay, next, starting on line 13, privilege from arrest in cases involving abusive litigation. And so this is the section that I spoke about earlier, which civil arrest being that allows them to take someone so that they can show up for a civil proceeding. For the new members, you'll be happy to know there's a specific exemption in this law just for you, which means that you can, if you are on your way to the State House and you have important State House business, you cannot be civilly arrested. So that's under existing law. This is just adding, and you might have, for those of you who were here last biennium, I didn't work on this, I believe Eric did. But I think this statute was expanded with regard to you can't civilly arrest someone who is going to court for a particular reason and then arrest them to bring them to an immigration hearing. Does that kind of ring a bell?
Yeah, we
Right.
extensively.
Right. All right. So you guys probably know much more about this particular statute than I do, but this is just adding to that statute.
It doesn't even pertain to this bill, but, so we can't be civilly arrested if we're coming to, do state business.
Mhm.
That includes speeding.
No,
No, you're not going to, this is for civil arrest being that, I knew that question was going to come up, no. Well, they're not going to arrest you for speeding, but they're going to cite you and release you Are you putting in a draft request?
I might need it.
This section is specifically to kind of take someone to get them to appear at a civil proceeding. And so this provision is simply saying that, sorry, I got my pages mixed up, that you'll see at the top of page 7 in subsection D, no person shall be subject to civil arrest for purpose of abusive litigation. So if someone under SB 8 in Texas files civil litigation against someone for facilitating an abortion, then this law can't be used to grab that person and force them to show up at a hearing related to that abusive litigation. Okay, so section 7. So this is creating a new chapter in Title 12, which is court procedure. My least favorite title and so you're creating a new chapter for legally protected healthcare activity. We're starting with a definition section, and I'm going to walk you through definition of abusive litigation. So abusive litigation here. So, we're using that term. It was interesting in talking with the chair. He was kind of like, well, should we use a different term because we're using it elsewhere in law? But just remember that, we frequently will use a term in different titles, different chapters to mean different things. Oftentimes, if it's too closely aligned, the two subjects will try to come up with something different, but whatever the definition is for that particular chapter and that context is the one that you use. So abusive litigation means litigation or other legal action to deter, prevent, sanction, or punish any person engaging in legally protected healthcare activity by filing or prosecuting in any other state based on legally protected healthcare activity that occurred in this state. Okay, so the legally protected healthcare occurred here, but someone in another state is filing litigation against the person. Page 8 at the top, attempting to enforce any order or judgment issued in connection with any action. You'll see on line 4, subdivision B, a lawsuit shall be considered to be based on conduct that occurred in this state if any part of the act or omission involved in the course of conduct that forms the basis for liability in the lawsuit occurs or is initiated in this state, whether or not the act or omission is alleged or included in any pleading or other filing lawsuit. And so that's a mouthful, and we'll come back to that. But the idea here is that, it doesn't have to be that the conduct occurred wholly and solely here. Because as I said, there could be other points of contact. And this is something that courts deal with all the time in determining jurisdiction. And they're trying to determine the contacts in the state with regard to jurisdiction. And this is saying that for purposes of abusive litigation in this particular chapter, if any part of it occurred in Vermont, then it's considered to have occurred in Vermont. Then the other definitions, the same, what we're using for legally protected healthcare activity. The definition of public agency on line 13 is from our public records law in Title I. It's generally what you would think. It's any agency, department, board, branch of government, of state government.
Does it include courts?
Yes. So starting on line 16, section 7302, starting out with statement of public policy for Vermont that access to reproductive health care and gender affirming health care is a legal right in Vermont, and interference with those rights, whether or not under the color of law, is against the public policy of this state. So we use the term under the color of law. Color of law means the appearance of a legal authority or an apparent legal right that actually may not exist. And so that's kind of a nod to, these kind of new laws that are cropping up around, like with SB 8, trying to use a civil enforcement mechanism for their abortion ban rather than traditionally how things are done, which it's the state, the government being the enforcement mechanism. So page 9. Any public act or record of a foreign jurisdiction, and when I say foreign jurisdiction, it just means not here in Vermont, that prohibits, criminalizes, sanctions, or authorizes a person to bring a civil action against or otherwise interferes with a person, provider, carrier, or other entity in this state that is providing or seeking legally protected health care is considered to be interference with the exercise and enjoyment of the rights secured by Vermont and is a violation of the public policy in Vermont. Subsection C, if any person engages. Sorry. Oh, sorry.
I'm sorry, it's going back to under the color of law.
Uh-huh.
I feel like I don't have a good understanding of that. Like it's saying even if it's not officially established in law, or if you can.
It's saying,
more, like,
yeah, so.
It's a gray area.
No, it's saying that, so there may be a statute somewhere else that gives someone the right to, let's say, sue an abortion provider in Vermont. It's on the books there. That state considers it's legal, but it may not be. Do you know what I mean? It once it works its way, the litigation works its way up through the courts or whatever, it may not be. And so, so that term essentially just means that, just because they have that doesn't necessarily mean that it's valid.
And it's a known term, like
It is.
okay. That's all. It's not known to me.
Sure.
Or me.
And you know what? And honestly, I had to like do a word search to see if we had it in statute anywhere. I had to do a little Googling myself. So you don't see it that often, but I think it is quite applicable in this particular circumstance, again, because we're seeing these really new types of state statutes that we really kind of haven't seen before in terms of reach outside their jurisdictions. So,
Actually, I thought it was an homage to the chair as an artiste.
I know. When are we gonna get some of your art in here? So C is basically if someone engages in abusive litigation, any aggrieved person, so it could be a provider, it could be insurance carrier, other entity, including any defendant in the abusive litigation, can initiate their own civil action for injunctive, meaning injunctive is basically saying stop it, monetary or other appropriate relief within 3 years after the cause of action accrues. So, this is a little bit like, okay, Texas, you're going to allow people to, sue somebody in our jurisdiction for facilitating access to reproductive rights. Well, then if it fits this definition of abusive litigation, then they have the right to sue you and to receive and to request compensation. So you see subsection D, any aggrieved person, or somebody who's a defendant in the abusive litigation can move to modify or quash a subpoena. Subpoenas are just written orders requiring a person to appear before a court or some type of legal proceeding that's issued in connection with the abusive litigation. So the idea of those, they've filed civil litigation in Texas and then they're looking to, and there's a provision in here that says that a court is not to issue a subpoena in those particular types of cases, but and then the person can just look to quash it and saying that it's unreasonable, oppressive, and inconsistent with the public policy of Vermont. If you look at page 10 at the top, subsection E, If the court finds for the petitioner, meaning the person who has initiated the litigation against the person who has sued them, recovery shall be in the amount of actual damages, so compensatory damages. So if you have to take time off of work to deal with this, if you have to hire a lawyer to deal with the fact that they've sued you and respond to that. So you'll see, which shall include damages for the amount of any judgment issued in connection with any abusive litigation. So if Texas says, oh yeah, we're going to give you, it's like, I think $10,000 per occurrence. So if there's that judgment in Texas that says, okay, there's a judgment against this person in Vermont for $10,000, and then you countersue under this abusive litigation provision, you can recoup that $10,000 that you're being required to pay according to the judgment in Texas, and any other expenses, costs, or reasonable attorney's fees incurred in the connection with the abusive litigation. Subsection F is just when a court can exercise jurisdiction. So first one, just jurisdiction over the parties. Second one, if the person's commenced any action in a court in Vermont. And then third one's just a catch-all exercise of jurisdiction permitted under the U.S. Constitution. And then G, going back to the issue of this doesn't apply if a lawsuit is initiated or a judgment's entered in another state that's based on conduct for which a cause of action exists under the laws of Vermont, if the course of conduct that forms the basis for the liability had occurred entirely in this state. So basically, if it's something that you could sue for in Vermont and the conduct occurred in Vermont, then this is not going to qualify. Okay. Page 11, foreign judgments. So in any action filed to enforce a foreign judgment, just meaning that there's been a judgment in another state that's issued in connection with litigation for legally protected health care. Or this should actually say abusive litigation. Make that for the amendment, unless y'all just plan to pass it as is. The court shall not give any force or effect to any judgment issued without jurisdiction, which is just kind of a given, meaning that they didn't have either personal or subject matter jurisdiction, or to any judgment that's penal in nature. And so an example of that might be the Texas SB 8, which is, and I think probably Professor Cohen can talk a little bit more about this exception. And this is going to the full faith and credit issue around states are required to recognize the judgments in other states, but there's a little room there. And if the judgment is penal in nature, then it has to be enforced in the state where it occurred. And SBA could be considered penal in nature because, usually if you're filing civil suit and you have a tort action against somebody, then you have to prove an injury, right? So you have to prove that you were injured and you are looking to recover and be compensated or have some type of remedy for your injury. The way that the Texas statute is set up is you don't have to have an injury in order to sue under that law. It's more viewed as kind of like a communal injury, right? So it's kind of looking at, like I said, it's instead of having state actors enforce the abortion ban, they've kind of tried to get around judicial review by having private citizens do it. But it could be anybody. The person doesn't even need to have any connection to the person who obtained the abortion services. And so what injury did they suffer? I think the goal, the intent here is to look at that and say something like that really is just trying to punish the person who's being sued for violating that statute and community standards in that particular state, rather than it being something where that person specifically incurred some injury personally.
So just a comment on this particular section, actually more of a question. So this really, isn't really changing current law. This is what the courts would do anyway. However, we're making it very clear by putting it in the statute here.
Right.
It's not doing anything momentous except really pointing out with
Yes.
respect to this area
Right.
that we want to make very clear that standard. And ultimately, the court is who will decide whether something is penal in nature.
Correct.
I would love to define that, but I understand that it's really up to the courts to decide that. Is that right?
I would agree. Yep. So next section 7304, we've already touched on that, just that except as required by federal law, a court in this state is not to order a person who is domiciled here or is located here to give testimony, a statement, produce documents or other things for use in connection with any proceeding in a court in another state if it's concerning abusive litigation. So what's, sometimes what others say, so if other state has a case going on and it's for abusive litigation and they want someone to come in as a witness, and then they will send something to Vermont, and then the Vermont court would issue a summons to that person to appear at a hearing and things like this. And this is saying Vermont courts, when it comes to this type of litigation, it's against our public policy. We're choosing not to recognize that, and you're not to require that person to appear. So it's going back to this kind of non-cooperation. Other state, we're not going to tell you what to do, but we're not going to cooperate with that. 7305, choice of law. This is just saying that the laws of Vermont shall govern in any case or controversy heard in Vermont related to legally protected healthcare activity, except as may be required by federal law. So there's a lot of different ways around the way that courts look at contacts between parties and the conduct in terms of what type of law is applied. There are circumstances in which, if there are multiple contacts, that like a state may either in whole or in part apply another state's law because of the contacts. But this is saying in terms of abusive litigation, we're going to go according to Vermont law. 7306 is a provision on non-cooperation, saying that no public agency, employees, et cetera, can provide any information or use time, money, facilities, equipment, personnel, et cetera, or other resources in furtherance of any interstate investigation that is seeking to impose civil or criminal liability upon a person for either providing or seeking or obtaining legally protected health care or assisting any person in doing so. So the state's not going to help out with that. And then B again is that kind of exemption language that the section doesn't apply, where the conduct subject to potential liability would be subject to that liability in Vermont anyway. Okay. Next section, section 5. This is the criminal statute that's modeled after the federal act. So you see subsection A is just some findings, just setting forth the policy of Vermont that all persons to be able to access healthcare facilities for the purpose of obtaining legally protected healthcare, and that the exercise of a person's right to protest or counsel has to be balanced against a person's right to be able to obtain that health care. Top of page 13, preventing the willful obstruction of a person's access to legally protected health care activity at a facility is a matter of public concern. And 4, it's necessary and appropriate to prohibit individuals from knowingly obstructing another person's entry or exit from a healthcare facility. Definitions there, you see the definition of healthcare facility, healthcare provider. I worked with our healthcare attorneys on pulling stuff from existing law. You'll see line 16, subdivision 4, physical obstruction means rendering impassable, basically the entrance or exit from a facility that provides legally protected health care, or rendering passage to and from the facility unreasonably difficult or hazardous. So When you get to subsection C, no person shall, and then back at the top of page 14, by force or threat of force or by physical obstruction, knowingly injure, intimidate, harass, or interfere with, or attempt to injure, intimidate, harass, or interfere with another person because such other person was or is obtaining or providing legally protected healthcare activity. And 2, knowingly damaging the property of a healthcare facility because the facility provides legally protected healthcare facility. It's designated as a 1-year misdemeanor with $1,000 fine, or up to.
Isn't that already law?
No, I think there are provisions under existing law that, depending on the particular type of conduct, you could argue could apply, like, maybe disorderly conduct.
Unlawful mischief.
Unlawful mischief, right? I forgot, we got an expert here, right? So, there are things that you can, but there's nothing specifically directed at this type. And so, again, this is kind of a model after what you have in federal law. And I think there are about 14 or 15 states that have their own version of this type of law on the books that's geared specifically towards making sure that people are able to, get in and out of a healthcare facility without, being kind of driven away by, someone being very intimidating or threatening or blocking the access to getting into that facility.
We'll take a break just in a few minutes. It shouldn't take too much longer.
No, I'm almost done.
Yeah, the last several pages.
Yes. So page 15, we already just kind of mentioned this earlier. This is just prohibiting the court from issuing a summons if there's a prosecution in another state concerning legally protected health care. And then the last section, which is the rest of the bill, are amendments to the address confidentiality program in the Secretary of State's office. So, you guys, this is all pretty self-explanatory, so I don't need to take but a moment on this. But if you look at page 16, talks about the intent and the purpose behind having the registry. And you'll see at the top of page 16, the folks who are currently permitted to avail themselves of this program. And then the new language, starting on line 5, of who can do that. So it's people who are either providing or facilitating or obtaining legally protected health care. There are a few little small changes that when I did send this over to the Secretary of State's office and asked them to share comments with me. Would this work for them? Any logistical issues? And they said, while you're at it, we have a couple little tweaks to this chapter that we think would really make it function a little better. And so there are a few little pieces here, which is, I can always go through them later, but they're very small. Let's see. Yeah. And then I don't think I necessarily need to go. I realize that we're getting on time.
One question. Should there be a savings clause in this as far as, it's one part of the bill?
No, we have that in Title I.
Title I, all right. Perfect. All right, so let's take just a 10-minute break because we only have David Cohen until 11:45, and there's a lot of ground that we probably want to cover with David. So let's go off live and we'll be back at 25 to 11.